We're here at Claim Game, and thank you very much for watching. I've got a great guest tonight with if I had to pick one person in the entire United States, and I wanted to get a history of public adjusting throughout the United States and all the issues that have been coming up, there's only one person I would think of right away, and that's you, Brian Goodman, because you know all the deep dark secrets where everything is buried and lied and made. But I'm thank you very much for coming here. What a lot of people might not know you. William Goodman, I believe, was your grandfather, right? And
That's correct.
and
He
the
was the
Goodman
founder of
family.
NAPIA, and he was my grandfather. Yes.
And then
Yeah.
the Goodman name has been in public adjusting, since the organized portion of public adjusting forever. And you've been leading it as NAPIA's general counsel for the last quarter century. But you also had a big family background, even before. And I think one of the questions I think a lot of people are probably curious about, and me too, and we've never talked about it, but you're a lawyer. Why didn't you become a public adjuster like everybody else in your
Well,
family?
it's funny. The couple things. When I worked at my family's business when I was a kid, high school years, and I would, you train kids to do inventories, and I'd go to these fires, and I'd come home, and I would smell like crap, and my mother would say, "Change your clothes on the porch," and I said to my dad and my brother Randy, I said, "How do you guys do this every day?" I said, "This is just not for me." But I kind of feel like, that scene in The Godfather 3 where Al Pacino says, "Just when I think I'm out, they pull me back in." So I'm practicing law for 15 years. And then suddenly, Harvey Goodman and Randy Goodman, they say, "Look, we're going to be needing a new general counsel soon." And they pulled me back in. So that's how it
And
happened.
here you are after all that stuff. Why don't just I'm kind of curious. So what do you do, day to day, and what do you do to help NAPI as the general counsel? What's your role?
So, as general counsel, I do a number of things. First of all, I monitor and deal with legislative issues all over the country. Do that in conjunction with Ann Froman, who's our excellent NAIC representative. And every year, you never know what state's going to be the hot state. Last year, it was Iowa. It's always Florida, Chip. I always say Florida is the Middle East of public adjusting. There'll never be peace. But a couple years ago, it was Nebraska. You just never know what state it's going to be. So I get involved with that stuff. I work on the internal machinations of NAPIA with the various committees, with the officers. I'm NAPIA now. Believe it or not, 10 years ago, we joined the Coalition Against Insurance Fraud, which is predominantly made of state insurance departments and insurance carriers. And we now have a seat on the board. So I sit on the board of the Coalition Against Insurance Fraud, and I deal with all kinds of issues relating to that. And then, of course, the last 7 or 8 years, since around 2008, actually longer than that, I've been dealing on a national level with what I call, and it's going to be on my tombstone. He coined the term UPPA, unauthorized practice of public adjusting, because we're seeing it everywhere. It has proliferated all throughout the country. It is a major problem for the licensed and ethical public adjuster. And I say I deal with that on a daily basis. In addition to that, I have my own, firm here in Baltimore and have private practice. So I have my litigated cases, and I do a lot of first party property litigation. But I really could work for NAPIA full time, and oftentimes I feel like I do. There's just so much. We're so much busier now than we were even when I started 25 years ago. I mean, it's crazy.
Why do you think it's so much busier, Brian?
Well, I think there are a number of reasons for that. I think that when the NAIC passed the model bill in 2005, once and for all, the argument that public adjusting is the unauthorized practice law kind of dead. And there was a model bill. That model was enacted. When I started working with NAPIA, I think 33 states licensed. Now it's 46. It's almost all 50. And so there are issues now in every state. Secondly, we are much more under the microscope because we have made great progress, and we've done a lot of great things, to educate when I talk about the NAIC model bill, for us to 40 years ago, we wouldn't have even been allowed to be at the NAIC. And now we're in the room where it happens, as they say in Hamilton. So it's I think all those things have just made for a much, much busier activity time period. That didn't make any sense. A much, much busier time for public adjusters.
You mentioned something. It's interesting because of the allegations of fraud and public adjusters. You always hear that from the insurance industry is one of the major problems with respect to public adjusting being out there. And now you're on the board of,
Right.
the Coalition Against Insurance Fraud. I mean, how does this happen?
I'm going to be speaking at their annual meeting in December. They've asked me to speak about what is a proper and ethical public adjuster, what is the practice of public adjusting, what does it entail? And one of the points I'm going to make is, the notion when a carrier, the notion that claims are inflated or public adjusters' estimates are too high, therefore they're fraudulent, it's ridiculous. People can it's just like a plaintiff and a defense lawyer in a courtroom. It doesn't mean that there's any fraud. If I always say, if the insurance industry paid claims fully and fairly all the time, there would be no such thing as a public adjuster. And my client, the people from NAPIA and other public adjusters wouldn't be able to make a living. So the truth of the matter is, good understanding of coverages and presenting a case. All public adjusters are really trying to do, at least the guys from NAPIA, are get their clients full and fair indemnification when they sustain a property loss, period. And I'm one of the things that I'm really proud of is that through our work at the Coalition Against Insurance Fraud, I think we're starting to chip away at the notion that licensed ethical public adjusters are all fraudsters. I mean, the problems that are being caused for us are the problems by these unlicensed people who are really practicing public adjusting, without any kind of license or training.
Somebody's telling me this. What happened? My background is what?
You have to turn your background on.
I lost your face, Chip.
You lost my face? Do they want me to just stop? Somebody's telling me.
All I see is a big C with a circle on it.
Well, that's all. I don't know if they want me to just stop now or Kathy McConnell's on here, and for everybody if everybody's listening, Ms. McConnell runs the whole stuff in the background, but I forgot to tell everybody they can also write in questions as you're talking here, but they're going to change my background.
I can fill in for you for a bit. So my apologies to everyone. This is a brand new platform for us. So we are working through the kinks. So we greatly appreciate your patience through this. And we are trying to get this to work. And Bernice, the lovely Bernice, is helping Mr. Merlin in the background there. So we're going to let them go to work. But we do want to mention that in the chat, you can ask questions. And we will choose them and see what we want to choose out of those questions. And then we will present those at about 20 minutes before the final hour. So I see already questions are starting to come in, and always Xactimate questions, my favorite. And so you guys just hold on. Maybe Brian, you could give us a little bit more background on you and currently what you are doing.
Sure. Well, as Chip mentioned, I was kind of born into the industry and raised in the industry, and my whole family's in the industry, and frankly, I am now too, obviously. But I'm a lifelong resident of Baltimore. I went to college at Johns Hopkins, graduated law school at University of Maryland School of Law. I've traveled a lot, but I've never lived anywhere else. And I also, in addition to my activities here, I am another piece of trivia about me. I run Baltimore's oldest musical theater company. And we are called the Young Victorian Theater Company. And we have been around for 55 years now. And I've been running it for 48 of those 55 years. So somebody said to me a few months ago, well, why don't you retire? I said, I really don't have any hobbies. Why would I retire? And the guy said, well, you run that theater. That little theater is a hobby. I said, little theater? It's like running a whole nother business. So that's a little bit more about me. And my practice, obviously, like Chip's, is concentrated in first-party property claims and do a lot of that kind of work. So that's a little more about me.
Kathy, am I back on? I guess I am.
You are back on, Mr. Merlin.
All
Yeah,
right.
I can see you, Chip. You're back on.
All right. If I'm back on, I'll keep asking. Well, let's get to it. You know, this could be a kumbaya type thing, and we just talk about that. But my insurance friends, insurance industry friends, they're concerned about the guys. Let's do this fairly. They're then concerned about everybody who's not ethical, that's not really playing right, who are just throwing crap up against the wall, I guess, for a better word, and what they perceive as just being a huge problem, not just for the claims that they individually have to handle, but also with respect to the public that might be being deceived by these individuals.
Yeah.
And
You-
so, what's the response, to you about that, and what can be done given that there are some issues about that?
Well, let me tell you some progress we've made there. And if I had my druthers, Nappia would be 25 times the size that it is. Every licensed public adjuster would be a member, because one of the reasons is Nappia has a very stringent code of ethics, and as a matter of fact, that code of ethics was put into the NAIC model bill, and so that code of ethics is actually part of the licensing statute in about 22 of the 46 states that license public adjusters. And I think and Chip, you and I have talked about this offline. There's also, one of the things my grandfather always wanted to do, one of the reasons he founded Nappia, was to make it more of a profession rather than a bunch of renegade, runarounds. And, ethical conduct was very, very important to him and the other founding fathers of Nappia. But again, because NAIC has put this in the model, and some states have put it, I think we have made improvements. But your friends in the industry are right. There's a tremendous problem with some public adjusters, a lot of unlicensed people too, but some public adjusters who aren't members of Nappia who don't practice ethically. But there are a lot of lawyers that don't practice ethically too. And I don't think the answer is to throw the baby out with the bathwater. I mean, I often tell regulators, they say, well, why would people hire a public adjuster? And there are a lot of reasons, but one of the main reasons is it is worth it to an insured to hire a professional. The insured, a lot of times when I get cases like referred in, I'm sure you've seen this too, Chip, the client will say, well, I should just get paid this because that's what I lost. They don't understand that they have to prove each and every coverage and each and every element of their claim. They're no different than a plaintiff in a lawsuit. And they have the burden of proof. And I tell regulators, to a lot of people, when they've lost so much, it's worth it to pay a professional who can properly prepare their claim. And frankly, I don't know why. I know why insurance companies don't want that, because the insurance companies aren't going to voluntarily say, oh, by the way, did you know you have a code coverage? Nobody told you that. You should really file that. They don't do that. But a public adjuster will do something like that. And it's really important. So that's the
Well, I
reason.
heard you talk about you would have everybody become a member of Nappia.
I would.
I think there's a perception that some public adjusters say, some try to get in, they can't get in to be public adjusters. And a lot of them say because it's a closed good old boys club and they left the public adjusting firm not on such good terms. I've heard others say, frankly, I thought Nappia was trying to get the very best of the public adjusters. So I want to hear if you can. Why don't you just expand upon that idea of everybody being a member of Nappia? Because I don't think that's the perception in the public.
Yeah, there is a perception in the public adjusting public that Nappia is a closed club, and back in the day when I was a kid, a lot of these guys did not want their competitors in the association. I mean, there was some truth to that. And I think it has gotten much better. It's not perfect, but I think it has gotten much better. I think that Nappia is now being run much more as an association, and looking to the greater good and putting competitive issues aside. But we're not perfect. And I think that one of the reasons that our membership and our membership is growing, but one of the reasons that I say I'd like to have many, many more members is that a lot of people don't really understand what we do and the value that we provide to members. For instance, I've spent the last 3 days with Ann Froman, Jeff Gould, and Alice Young at the NAIC convention in Minneapolis. We met with the commissioners of the states of Utah, Maryland, Kansas, 3 or 4 others in the individual meetings. And, you know, that benefits everybody. And maybe we're not advertising it enough, or we're not putting it out there enough, but that's the kind of thing that really helps everyone. Because I can tell you, having now been at the NAIC since the early 2000s, if there's an issue in any state between Ann Froman and myself, we have connections in every state's insurance department, and we have people we can call. And it has benefited us, and it benefits the public. That's why there's great value into joining NAPIA. I really believe that.
Oh, I appreciate you bringing that up, and I think it's a point that could be more publicized about it and even discussed at NAPIA. So congratulations for you mentioning it.
Yeah.
You know, one of the things when we were talking about issues of fraud and raising, you know, who can become a public adjuster and making it more of a profession that your grandfather really wanted to see. I've been a proponent. I know Steve Badger, who might be watching as recently as last week, was being more proponent. The current president, Justin Skipton of NAPIA, has said this, and I think you have too, of trying to raise the bar about what it takes in order to qualify to become a public adjuster. Just frankly, you have to have certain qualifications to get here. Not everybody's going to reach those, and that's okay because we're here for the public. But to me, I've always thought that might be a way to keep people that are just really in it to make, you know, a quick buck and move along and take advantage of people from doing so. So
yeah.
What are your thoughts?
One of the things that I'm really proud of, I will tell you, you know, public adjusters have continuing education requirements, and most lawyers do. Lawyers in my state do not, which I think is not right, but I'm not, you know, active in that issue. But the point is, I've gone to, you know, continuing legal education seminars, and I've gone to every NAPIA seminar in the last 20 years. And I will tell you that our continuing education is by, you know, A to Z outstanding. Speakers like you and so many others who really know the business and really know the industry, whether you're talking about business interruption or Xactimate or whatever the you know, the color of the day is. I mean, I've talked ad nauseum about UPPA. You know, that is a terrific benefit. And I think that's the kind of thing, when I say that I'd like everybody to be a member of NAPIA, you know, people have to get CE credits in this profession. You're not going to find a better place to get them than the ones that we sponsor and that we do. They're really good.
That's one issue. What about having just to qualify to take the test and even raising the difficulty of the test?
Yeah, and look, Badger and you and I have spoken about this. Many people, and Jim Beneke too. He's one of our you know, past presidents from Texas. I would like to see the qualifications made harder. But one of the problems is that I mentioned this to you offline before we started today, Chip. You know, as these remember, each state runs its own. Insurance is regulated at the state level. So, you know, many people who are members of NAPIA have multiple state licenses, but they're state by state. And at the NAIC level, commissioners come and go, and insurance department staffs come and go. And sometimes you get a commissioner when they come in. He or she may be fully conversant with property and casualty and may know all about public adjusting. And a lot of times the new ones do not. So by the time we finish trying to educate them about who we are and what we do, they're gone, right? And so how are you going to improve the testing, make the testing more stringent when it's administered by the state insurance department and those departments are ever changing? So it's a real problem. I mean, it's because I think that it's a good point. If you made it tougher to get into the profession, you know, I mean, I know it was really hard to become a lawyer, and I tell you what, I would never do anything to mess around with that license because I had to work so hard to get it, and you did too, right? And I think that the same thing should apply to our profession. I don't have a magic bullet answer though as to how you do that.
I think maybe one state at a time, and I would suggest, but you know, I think for the same reason that bookkeepers look at CPAs and they go, "Oh, you got a CPA license."
Right.
When the day comes when insurance company adjusters and independent adjusters would say the same thing and go, "Oh, you got a public adjuster's license?" then you know the public adjusting profession. I mean, profession has really arrived. Until that day comes, it's a lot of people are going to consider it a trade, and you're going to have a lot of other issues with it.
It's a good point. And, it's funny because I remember, back in the day, I mean, tests have gotten somewhat more stringent. And back in the day, one of I don't remember who it was. One of the old guys in Appia, they were talking about one state and said, "Oh, well, you could be an orangutan and pass a PA test in that state." And I think that they have made the tests better, but the problem is that the other problem is with enforcement, right? We talk about UPPA. We do a chart. You've got it, and everybody who's a member of NAPIA has access to it. Which we renew every year, which is a licensing chart. And one of the categories, one of the columns we have in the chart is UPPA a crime? Is it a crime to practice public adjusting without a license? Now, let me tell you, the Model Act that was just amended through the great work of Ann Froman and Jeff Gould for NAPIA, they now, in the Model Act, the new Model Act, it does make it a crime. It's misdemeanor, but it makes it a crime. And about 11 states currently do that. The problem is, even though it's a crime on the books, it's rarely, if ever, prosecuted. It's not a sexy crime. So, yeah, it's on the books, but nobody ever gets prosecuted for it, with some rare exceptions. Now, there is a developing body of civil case law, though, about this stuff. I mean, you look at the Lon Smith line of cases in Texas, and you look at those 3 cases that came out of Iowa last couple of years, 33 Carpenters case, which said you cannot, all contracts with these roofers or these contractors are null and void because they're public adjuster contracts, and you can't do that without a license. So we are developing some case law that is recognizing the fact that it's a licensed profession. But again, it's all done at the state level, and Iowa may rule one thing and Florida may rule something else. So
for all of my restoration contractor friends that are listening into this, that what he just mentioned is something that should cause you concern. It should make you look at your contracts. I wrote a blog afterwards saying that every single restoration contractor should go back, because if your contracts are void or voidable, it doesn't take a lawyer a second or two to say, well, you probably have 500 or 1,000 contracts that are written that way with the boilerplate, and you're gonna have to give back all that revenue to whoever you did the work for. So,
for the public adjusters who are listening, and I'm sure there are plenty, remember, most states have specific requirements that must be in public adjuster contracts. And some states go so far as to say they got to be a certain font or they got to be dark lettering. If I was a public adjuster, and I'm not trying to drum up business for myself, but I'm just saying, if I was a PA, I would make sure every year you had your lawyer review your contract for compliance. Because, one of the things that I always tell, unlike company adjusters and independent adjusters, I tell these commissioners, we being public adjusters, we want regulation, we want accountability, and we want you to be looking at everything we're doing, because it's only fair. We're here to protect the public, as are you.
Well, I'll take that a step further. I also think, that every insurance company claims executive out there wishes that they would just have public adjusters be gone and done away with. And now we're seeing some surplus lines carriers start to actually place that into their contracts, saying it's going to void the policy or to be a breach of the contract if a public adjuster is hired. And I know if I didn't ask you that question, but today everybody go, how come you didn't ask that tough question? But what can public adjusters do about that? What are you doing at the regulatory level about this? And
well, one thing public adjusters can do about that is move to Texas, because they've made that illegal in Texas. The Texas legislature, saw the ridiculousness of this and the unfairness and the illegality of this, and they just passed a law that said you can't do it. We don't care whether you're a surplus line carrier regulated by the state insurance department or not. I'm hoping other states, get to that point as well. The problem with that anti-PA endorsement is a typical problem. Nobody reads their insurance policy. Okay, so nobody reads their insurance policy, so they have a fire and they say, well, I'm going to hire public adjuster X, Y, or Z. Well, you can't. Why not? Well, you have this in your policy. Well, and most states have the requirement in the law that an insured is charged with knowing what's in his or her policy. So, this is a major problem, and it's something that has to be studied and dealt with, and I hope we can rectify the situation.
Well, I know that I've personally looked around just to try to find the right case. The problem is trying to find a policyholder who will say,
Right.
I'm going to take the risk and not fire my public adjuster. And that's a difficult deal to do. I
Right.
personally think that there's some issues of
On this
antitrust.
issue, I've presented the surplus lines committee at NAIC, and they knew nothing about this, and they were appalled. The problem is there's nothing they can do, really. But the more you raise awareness, the better. And this is a marathon issue, much like UPPA is. That issue wasn't going to be solved in a day. When UPPA started to get really bad in 2008, and there's more awareness of it now. We're developing a good body of case law about it now. But it wasn't solved in a day. And when you said to me, why are things so much busier than they were, when I was in my 20s, 30s, 40s? Well, it's because all these issues have come up, and they're monstrously large issues. And, the truth of the matter is public adjusters are not hired on most claims. But, if 46 states recognize us as a regulated profession, nobody should be able to just write a contract and say you can't hire somebody who's recognized in the state as being a professional who can help you with the claim. That's just not right.
I've often thought, most of this is coming out of the surplus lines market, who seems to be growing and becoming less regulated all the time. I mean, they're the ones that are creating the problem with writing clauses into the policy that require litigation or arbitration halfway around the country. For a lot of them, pick a choice of law that's going to benefit them, and really to the detriment of policy.
Well, and how about what just happened in your state of Florida, Chip? It used to be in Florida that a broker or an agent had to contact 3 domestic carriers before they even turned to getting a policy from a surplus lines carrier. They don't have to do that anymore. And you wrote a blog. I read your blog a lot, and you wrote a blog, and I think you wrote that surplus lines had $40 billion of premiums written in 2023 in this country. So, back 20, 30 years ago, surplus lines were just that. They were people who couldn't get insurance elsewhere on the regular market. But now they're just other insurance companies, and they are wholly unregulated. So it's
that's an issue. I tell everybody, I said, just a reminder, there are antitrust laws that still apply. I'm not certain how far we ought to go on that, but maybe they should have zero antitrust exemption whatsoever. I've told, so if the surplus lines carriers don't want to be regulated, just make certain that they know that they don't have any exemption from any of the antitrust laws. So they're just like every other business that's not regulated.
Right.
But,
I mean, they're not. It's like they think they're Major League Baseball or something. Come on, So,
Well, what's other than the UPPA and the anti-public adjuster, laws that are out there that seem to be taking up a lot of the concern that you've gotten, probably, complaints from members. What are the other major issues that are facing public adjusters today?
Right. Well, fee caps are a big issue. I think 13 of the 46 states that license have some sort of fee caps. And, NAPIA's position on that is we don't ever go into a state and advocate for fee caps. But if a state makes it clear they're going to have them, we work to make sure that they're going to be fair. For instance, post-Katrina, when Mississippi enacted a licensing bill, and that's a whole nother story, after George Dale threatened to arrest every public adjuster, and I asked for the Attorney General to write an opinion, and he wrote an opinion and said, no, they can do this. So we got that, paved the way for licensing. But they were going to enact a 7% fee cap. And so we convinced the legislature, look, you can't do, that's not fair. I mean, that's just not, people have to make a living. So they have a 10% fee cap. And as far as I know, public adjusting is working very well down in the state of Mississippi. They actually also, I believe, just passed an anti-UPPA law this year, like a storm chaser law. I think it's restricted to roofers, but so they get it. And George Dale, actually, he and I become friends. He's no longer the insurance commissioner, but back then he was the longest serving insurance commissioner in the country, and he hated me. But we've become good buddies. Another issue that is a big issue is this issue of rescission. It's funny. I've mentioned the NAIC meeting. My state, Maryland, passed a law last year, misguided law, where an insured has a 10-day right of rescission. Now, that's the only state that has most states, the model bill has a 3-day right of rescission. Most states have a 3-day, a few have a 5-day right of rescission. Maryland has a 10-day right of rescission. And, I told the commissioner, she's a brand new commissioner, but I told her, I said, look, when my guys get hired, they have to do so much in the first 5 to 10 days. It's completely untenable and unfair. And, she was very polite. She's going to look at it and everything. But rescission rights are something. And again, this goes back to contracts. Most states that license, you have to put a right of rescission in dark lettering in your contract. Right. And so that's always a continuing issue. So you've got rescission, you've got fee caps, solicitation rules. That's another one. Some states have tried through the years to enact laws that say you can't solicit for 48 hours, and we've litigated that issue on a number of occasions. Ron Pop, I think, was involved in most of those litigations, and we've won every one. So we will work with states on hour restrictions, like 8 p.m. to 8 a.m. or whatever, but you can't give blanket solicitation restrictions on days. But the problem, even with hour restrictions, that doesn't apply to contractors. So Jeff Gould will tell you some horror stories. He told, of people, contractors coming, paying for a hotel room for a family that just got displaced. And then the next day, the public adjuster who they're working with shows up to sign them up to a PA contract. So there's all those kinds of shenanigans that happen. And it's, you do the best you can. I mean, NAPI is a pretty small organization, and I'm just one guy. I mean, people at NAIC and everything, they're shocked to learn that I'm not, they think I'm full-time for NAPI, and I'd love to be, but that's just not the reality of it. So there are a plethora of issues, Chip, that come and go, and they're very challenging.
What are the big legal issues that I know NAPI every now and then writes an amicus brief on behalf of others and participates? What are some of the bigger issues on those from the
one of the huge legal issues right now is assignment of benefits. Actually, there's a division among the states. Iowa says can't do it. And what's happening is contractors are using these as runarounds against public adjusting laws. They said, just assign your claim to us, we'll handle everything. And, Maryland, just recently, the Supreme Court of Maryland said, oh, it's fine, you can do that. There's no, but that is a huge legal issue. And the state of Rhode Island and Delaware have enacted part of their statute to the smallest states in the country, I know, but is it you cannot use assignment of benefits. But that's a recurring legal issue that we get, and we often write amicus briefs. Here's our standard for writing amicus briefs. We're not going to get involved in an amicus brief if somebody's having a fee dispute with a client or with an insurance company or something like that. But if it impacts public adjusters' ability to practice, that's when we get involved as an amicus writer. And it happens, we write 2 or 3 a year. We wrote one 2 years ago for the Supreme Court of Connecticut on an issue of matching. And we wrote one last year in Maryland on that Maryland case on AOBs. It varies.
So in the AOB on the assignment of benefits, which way did NAPI write? I mean, or for the ability to have the assignment?
Well, our amicus was very narrow. Our amicus took the position that nobody who is not a licensed public adjuster should be able to use an assignment of benefit, a blanket assignment of benefit, as an end run around so they can handle the claim as a public adjuster would. And the issue was an issue of this was a roofing company, as I recall, and they were taking assignment of benefits, and the carrier was Travelers, and they took exception to it. And the Supreme Court said, look, it's freedom of contract, and they can do it. And I don't think the Supreme Court really focused on our particular issue and how it impacted us, but that was the position we took.
If I was to ask you on your desk right now, what's the biggest driving thing that causes you concern regarding public adjusters, what would it be?
Well, I honestly, I worry that between UPPA and the surplus lines, what's going on there, I worry that all these forces are serving to attenuate the profession, and we could be out of business if we don't address them properly, which I think we are doing, certainly at the NAIC and at the CAFE level, and at some legislative levels too. But those are the two monstrous, mountainous issues that are really facing us right now.
If you wanted to say something to every person who's a public adjuster out there who's not a member of NAPIA that would convince them, you think, about the reasons they should join, give me the top 2 or 3.
Okay. Number one, you would the best of the best. You'll be exposed to the best public adjusters in the country, because we've got some giants at NAPIA, some people who are super, super smart and are happy. You talk about it's a club. I go to all the meetings and I see the giants of the industry, take young people under their wing, and they're happy to share their knowledge with them. So that's number one. Number two, you got to take continuing education credits. You will get the best continuing education you will ever get in the first party property realm by coming to the NAPIA meetings and the seminars. And number three, by becoming a member of NAPIA, you will have to live by the ethical constructs in our ethical rules, and it will only benefit you as you go forward in the profession. So those are top 3 things that I can think of right now.
What's the most difficult aspect that you have with respect to going to insurance commissioners, as the general counsel for public adjuster for NAPIA?
What's the hardest thing about doing
Yeah,
that?
what's the most difficult part when you go to quarterly NIC meetings? I know I get reports, you talk about them. What's the most difficult aspect of that, Brian?
There are 2 things. Number one, we cannot compete with the power and the numbers, the sheer numbers of NAIC lobbyists for the insurance industry. Okay, you're talking. We're like a midget. That's not right. You're not supposed to use that term anymore. But we're like a little speck, and they have a lot of influence with the commissioners, and the commissioners, some commissioners are elected. They get money from their PACs to run for elections. That's number one. And the second biggest problem is, and this touches on something we've talked about, I'll never forget, I was in a meeting with the California Insurance Department, and one of their deputy commissioners said to me, well, Mr. Goodman, that so-and-so, that gentleman, he was an unlicensed public insurance adjuster. I said, sir, you understand what you just said makes no sense. If you can only be a public adjuster in California if you have a license. If you're unlicensed, you're not an unlicensed public adjuster, because you're not a public adjuster at all. These are bad actors. And she looked at me and she said, you're right. So that's a problem, because because they still refer to these bad actors as unlicensed public adjusters. They're not. There's no such thing. The only place you can be an unlicensed public adjuster is South Dakota and Alaska, because those are 2 of the 4 states that don't license but let you work. So they're the only places. Every other state, the other 46 states, you have to be licensed to be a public adjuster. So that's very frustrating, and that's a discussion I have at every one of these meetings.
Kathy, I think we're about 20 minutes away from maybe end. Do you have any questions that have come in that we could you can pick and we can go from there?
Yeah, I've got some great questions. So Dylan asked a question: how can we leverage the power/influence of mortgage companies to ensure insurance coverage on their vested interest, eliminating the 1% matching and $5,000 in water limits? He doesn't understand why mortgage companies permit these specific limitations on policies given their direct financial interest in the insured properties? What are your comments?
That's a great question. I will tell you that I have found that every mortgage company is very different. For instance, I'll give you an example. I just settled a case, and there's a mortgage, and there's a public adjuster involved. I represented the insured, and the mortgage company had a lawyer, very smart guy, and I said, look, we're all going to be parties on this check, so you got, and the mortgage company understood that the public adjuster and I had worked to get this settlement, and they said, yeah, we will pay you. You endorse a check to us. We will pay you out of the proceeds. Now, some mortgage companies would say to me, hey, we're a party on the check, and we're gonna pay out who we want, when we want, how we want, and then it ends up you have to interplead the money in court, and it's a mess. So there's no. I'm not answering this question directly. The problem is that there's no uniformity among mortgage banks as to how they deal with situations in first-party property claims. Chip, you may have other thoughts on this.
Yeah, I think it's clearly, if it's a secured mortgage, and what I mean, one that can be marketable and transferred, there's certain rules for what are required for those mortgages, and one of those is to have a replacement cost insurance policy that satisfies the standards of Fannie Mae or Freddie Mac, and here are the standards, so that if you invest in mortgages, which and financial entities do, you can rest assured that this is the way these policies supposed to be. These are the minimum requirements for the policy, and unfortunately, that's not going on. Any banking regulator, the Federal Reserve banks, and all the banks that are regulating the banks, if they were to actually take a look at these insurance policies, they would find today that there are many policies that really aren't full replacement cost policies. They say they're replacement cost, but when you start limiting matching, when they don't pay overhead and profit until it's finally, quote, repaired. And so if it doesn't get repaired, you don't get paid that. It's not even in the calculation for actual cash value. So it's worse than an actual cash value policy. When I think the banking regulators see what's going on in the insurance marketplace, that there's these huge insurance coverage gaps that are against the regulations, and then you'll find change. But until they actually start looking at it, which is going to cause a huge concern, insurance industries are part of the financial institutions. They actually are one of the big investors in mortgages, believe it or not. But they're selling a product which is not in conformity with the regulations for the mortgage. By and large today, most of the carriers, they keep doing this what I call Swiss cheese selling of their product. They get a lower product, sold to the public at a lesser price because, frankly, it's not worth crap on some of these. You have an insurance policy that has on page 23 of 26 a $3,000 additional payment for mitigation. Well, it used to get full amount, not a limit to 3,000. Oh, and you get more than that if you call one of the vendors, that we have, and we approve it within 48 hours. Well, nobody reads on page 23 or 26 of that policy. And so it's almost like you have a $3,000 limitation on the water loss. So, that to me is the issue. And I'm not in the banking regulation industry. I don't know why banking regulators aren't asking about this. It is a huge issue. The truth of the matter is, if people can't afford to buy insurance of what's required, for your mortgage, they really can't afford the mortgage, because they certainly aren't going to be able to afford to pay for the loss afterwards. Because if you can't pay for the mortgage, certainly you're not going to be able to pay for the loss. So, there's an issue there. But that's not what I do for a living, but I think that's the answer to the question, maybe.
Well, one practical piece of advice I'd give to any public adjuster attending today or listening, if you are involved in a first-party loss where there is a mortgage company involved, I would start talking to the bank right away, and not when you're ready to settle, resolve the claim. Because, open communications, the bank's going to have a lawyer, probably in-house, but usually somebody who will work with you to make sure that your fee's protected, but also, to make sure that they're kept, because, remember, the mortgagor has a duty to cooperate also with the mortgagee, which is the bank, just like the insured has a duty to cooperate with the insurer. So, I just would encourage that line of communication to be open right from the start.
Yeah, I mean, in our law firm, there's one person that's designated to deal with all the banks and the mortgages because it is a pain. And some of the larger public adjusting firms, they have one person that's all that individual does
Yeah.
is deal with the banks, and it certainly helps out. Kathy, what other kind of questions do we have other than mortgages?
All right, I got a good one. So Carrie says she's interested in whether either of you have had any experience with pushing back against quote unquote captive experts used by insurers to deny or limit claims for urban wildfire partial loss claims, in particular, industrial hygienists and structural engineers. In LA, these experts are limiting the scope of testing and refusing to allow the policyholder to even see the agreement between the insurer and the experts or the full results/report. Thoughts?
Well, you're my guest, so you get to go first, Brian.
All right. Well, look, this is not only a problem in I mean, I do third party work too, personal injury work, and believe me, you know, one of the great ways to cross-examine an expert is to show that he or she is in the stable of the insurance company. And that's a trial tactic issue. So this is not a unique issue to first party property claims. I have no experience in the California wildfire claims. Chip probably does, so I can't really speak to that. But I know one thing. There's become a big issue in the appraisal area because under the policy, appraisers have to be competent and disinterested, and those are the two. Which means, you know, you can't be in the regular stable. And the cases, there've been a lot of litigated cases on this issue. So I think things are changing a little bit, but obviously, you know, just like insurance companies have doctors who do all this work for them, and you cross-examine them on it. It's just a matter for the jury to determine. A lot of times, you know, there's not, you know, you can't fight City Hall. It's the way of the world.
Well, I think the issue with respect to, you know, call them captive, look, they get paid so much money. The real question is now, are they outcome oriented because they're so biased for what they do? I won't say the name of the company, but there's a surplus lines manager who this company invites all their vendors to come in, and they call them partners. They're partners. They even get, you know, awards for it. And so here's this partner getting this award, and sure enough, you can guess which way the opinions might go with respect to the policyholder. Regarding the wildfires, absolutely. They make so much money, but it's not just that. The insurance companies for the wildfires are dictating what a lot of the experts can do, because it's extraordinarily expensive to go through and do a search for all the areas behind the wall cavities and all that kind of stuff. So first of all, the more that you do the work, the more it's going to cost the insurance company. That's one factor why the insurance companies don't want to do it. The second is, if they find something, now they got to pay more money. And so it's a lose-lose situation for the insurance company. And maybe the only way around that is for their experts to come up with every possible reason why, you know, they're not going to do this. I was at I gave a speech last week to a group of public adjusters, and a pretty big group, at 55 public adjusters. And they invited in a business interruption person, and the business interruption actually was a couple. And one of the partners of that firm used to work for a well-known accounting firm that does nothing but business interruption for the insurance industry. And I finally put my hand up because I was concerned. I said, you know, do they sit around and ask what are all the possible ways that you can try to reduce the claim and stuff like that? And I swear to God, there's this long, pregnant pause, and I couldn't help myself. I said, see, they've got to you too. And I hate to say it, you know, there's so much. I mean, it's hundreds of millions of dollars that are getting paid to these experts. This is big money, you know, through the group, and there's a lot of pressure. I think the reason why Doug Quinn's, you know, group, you know, is out there, and Doug felt it himself, was to raise issues about outcome-oriented experts. And so that's just kind of, and I find it out here with the wildfires. Absolutely, I'm here in Los Angeles. I'm not in my hometown in Tampa. I'm out here in our Century City office because of the wildfires. I'm, you know, when I'm not giving a speech somewhere, or sailing my sailboat, I guess I'm here in Los Angeles fighting these fire claims. So I get the question, and it is very timely. What else?
There's also, I don't know if you all are familiar with this, but I'm chair of the Coalition Against Insurance Fraud internal fraud group on property and property insurance, and we're doing a webinar at the end of the year in December, and the two things we're talking about, I'm talking about UPPA, but then there's this thing in California I never heard of called water arson. Have you ever heard of this? Where people aren't burning their properties down now, they're flooding them out. And there's ways they do it. You know, they create these floods. And I said to this guy, I said, I have never heard of this, but apparently it is at least in his mind, it's a big problem in California. So I don't know if that's creeping away across the country, but that was news to me.
Well, I tell you what, you might hear the word until you just mentioned it. I've never heard it before, but
me too.
Oh, the water arson. Yeah, that might make it on the blog soon. So
yeah, okay. I'll fill you in on this. You may know the guy who's advancing this issue, Chip. I'll talk to you offline about that.
I mean, anytime.
How about some more questions?
Any type of claim of policy.
Rocking and rolling.
If it's a fire claim, it's arson. If it's water, the policyholder did that one too. You can't win anyway.
Oh my goodness. Okay, so Frank has a question for both of you. What do you guys think about Regulation 10 in New York? Do you think other states like Florida should push for getting PA fees separated?
I think I'll tell you one thing. I'm not an expert in Reg 10, but I know that it works well in New York, and most public adjusters that I know who work there like it and thinks it makes their job. I don't want to say easier, but it clears things up in terms of what they can do.
It's an interesting concept. You know, I always represent the policyholder and what's best for the policyholders. I know at the time of payment, I get a check that has my name on it and my client's name on it. And if there's an issue that comes up, that's when they ask for it. There's no law that says I get to cut my attorney's fees separate, that my client would actually have to sign something that would say that and approve, and they still have to approve my fee. So to the extent that what it would be, you know, for people that are upset, policyholders that don't want to pay because there was not a true performance of what was promised, that's the only time for them to say something, you know, and try to work it out with the public adjuster. And I understand public adjusters want things so that, well, they can't do that. I'm going to get paid right away. And we have some people that just don't want to pay us. They hold off on it. And so we have these problems. So, you know, I think that's where the rubber meets the road. I really hadn't thought about it until you just asked me right here. And I'm giving you my first answer off the top of my head. I bet most good public adjusters, it might be a pain in the neck, but talking with your client at the end and making certain they have a smile and they're going away and they're pleased is probably the best thing that could happen for the profession, even if it might be more difficult for you to get paid right away. Next question.
All right, we have a final question from Alex. Do you think public adjusters will be allowed in Alabama soon?
No.
And why not?
I mean, look, I have fought that fight. I would like nothing but look, my goal before I retire or die, we got 46 days. I want to get all 50. And I think I'm never getting Alabama and Arkansas. And the reason is because we've tried. We've spent a lot of time and money, and we've tried. The bar associations down there consider us competitors. They don't understand who we are and what we do, and they just don't want us around. They're the only two states that still engage in this ridiculous notion that it's the unauthorized practice of law. And I've beaten my head up against a wall for many, many years trying to get licensing in those states. So I'm not a defeatist and I'm never going to give up. But if the question was, is it going to happen anytime soon? And there's an unequivocal no.
So let me tell everybody a little story. When I first started working as an attorney, there was this judge and he said he started working with insurance companies as a lawyer, and he would settle out the claims. He worked in the claims department and then went on to explain to me that most of the people in the claims department doing third-party liability claims were lawyers, because it used to be it was only lawyers that could go ahead and settle liability claims. They did not allow adjusters to do that. And if you go back historically in the 20s and the 30s, they had to reach a special convention with the bar associations and everybody else. And the one state that was holding out on this to prevent adjusters from being able to even settle liability claims was the state of Alabama. And so it should come as no surprise historically with the culture that's there that Alabama is going to be taking the same position with respect to the adjustment of first party claims for the policyholder. So which that's not even the insurance company, because they didn't want to have anybody selling liability claims for the insurance company back when this first was raised then. So I feel for you, Brian. I'm certain there's a lot of people that would love to go into Alabama and practice public adjusting, but
I could talk for an hour about my experiences in Alabama and Arkansas trying to get licensing. Maybe that's another seminar one day, Chip. But it's just those are our two white whales.
Well, let's wrap this up, Chip.
Those are all the questions so far?
Yep, we had an amazing conversation happening between Brandon, Nancy, Carrie, Stephen, Mike, and Michael. I've enjoyed watching everything in the chat. So I just want to personally thank everybody for being so engaged as a community in the chat. That's the purpose of Claim Game, and we're just so glad that y'all were here.
If it's Nancy, imagine it's Nancy Dominguez and Brian. You one time, as I recall, were there when as a NAPIA, you were at a board meeting with respect to FAPIA a few times, but I can remember one in particular where there was a fight almost broke out and one of the guys stomped away and everything. But what's from your perspective as an outsider? Because I don't feel like I'm an outsider in Florida. I'm there all the time. What's your perspective of Florida?
Well, wow. Okay. Florida obviously is always going to be one of the 3 or 4 most active states for public adjusting. And I think I've gotten to know Nancy very well over the past 3-4 years. We've been working closely together on some stuff. She does a great job as the executive director of FAPIA, and that group is extremely professional and they're great to work with. Florida, the problem with Florida is you've got now Nancy. She'll correct me if I'm wrong. She's saying, "Be careful, Brian." I just saw that. Florida has so many public adjusters, more than any other state, and I think it's over 3,000. So it's very hard. It's because of that, and because of all the natural weather events you have in Florida, you're going to have issues in Florida. But I think that at least from when I started back in 97, 98 to where it is now, I think things are looking up in Florida for the profession. And again, I think they've got a really good administration now running FAPIA. So that's terrific.
That's a pretty diplomatic answer.
Well, it's the truth. I mean, really, I didn't just get scared because Nancy wrote, "Be careful, Brian."
Nancy's getting lots of love in the chat from everybody anyway. So all is well.
Yeah. I think that, some of the issues that come up, from whenever there seems to be legislation that comes up, the insurance lobbyists seem to be very successful in arguing that it's either the lawyers or the public adjusters or a combination of both, along now with contractors and frivolous claims and frivolous lawsuits and always inflating too much. And I'm just kind of curious, what's your stock response back to all that, Brian?
Yeah, I say you feel that way until it happens to you or somebody in your family, and they're not getting treated fairly, and then you'll change your perspective. So that's my stock answer. And look, I've worked for insurance companies, and that's when I serve as an expert witness, and they try to paint me as a one-trick pony. I say, wait a minute, I'm not. I see both sides of everything. So but it is a problem. Anytime they don't want to pay out a claim. I was mediating a case in front of a federal magistrate judge, and it was last year. It was a roofing case, and I'll never forget. He said, "Well, Mr. Goodman, I've known this guy forever. He was a year ahead of me in law school." He said, "This case shows the two things that all claims adjusters are taught: collect premiums and deny claims." So he got it. I mean, when you have a good righteous claim, and you're not, you're just trying to get fairness for people who paid a premium. Generally, that works out in the long run.
No, I was around long enough to have heard Paul Cordish give, and he was the former general counsel for NAPIA since its inception until you took over.
Yeah.
But, I had a chance to always hear him give his annual speech, but this is kind of a final question, but how old was Paul when he finally turned the reins over and you took over? And how old are you today on this? And are you just going to do this until I think Paul must have died almost right after he finished up on this?
He was 86 when I became associate general counsel for him for 3 years, and he was 90 when he retired and I became general counsel. I'm in my mid 60s. I'm about your age. And I mean, right now I'm healthy and I think I can still think straight. So I don't have any plans to retire, but I'm not going to work till I'm 90 at this. It wouldn't be fair to Nappia. So we'll see how long they want me. But I feel good. I have a lot of energy and I have a lot of, I've got a lot of knowledge in the area.
Well, I wrote a blog and called you the good shepherd for taking care of all the public adjusters and being in their corner all the time and looking out for them. And sometimes that's also with some very tough, discussions too, going back about the profession. And just, I wanted to say thank you for all your work. It's very important. I think the purpose of public adjusting is extraordinarily important. And the fact that they have somebody that is of a person of such high character as you underlying the decisions and the strategies of this association means a lot. So thank you for all you've done, Brian, and thank you for coming and being on the show.
Well, thanks for your kind words. And you two are a giant in the industry, Chip. So thanks for having me. It's an honor.
Well, thank you, everybody. This is Claim Game. We'll have Kathy will make sure this gets up on Claim Game as soon as we get this recorded and we get it transcribed. And I'll certainly be writing some of the highlights of this. And thank you very much for attending and watching.
Thanks, everyone.